Ready?
Ready?
We ready, everyone?
Alright.
Yes, Mr. Mackenzie.
May it please, my lords, I hope it will be useful for me to begin by outlining what are in effect my headline submissions on the issues that arise in the context of this case. And once I've done that, I will effectively just move on to more focused submissions under 5 heads, which I'll tell you about after my headline submissions.
Thank you.
My lord, just before the luncheon adjournment, Mr. Wilcox, in answer to a intervention by my Lord Justice Arnold, said that the relevant circumstances justifying list alteration in this case were that the property became incapable of beneficial occupation. And I would entirely accept that. And if that's right, which I submit it is, then it follows quite naturally that those circumstances ceased to exist when the property was rendered capable of beneficial occupation on the 23rd of January 2015. That answer, however, was somewhat inconsistent with the way that the case had been pleaded, or at least the way that I had understood the case to be advanced until that point. But so far as it is said by Mr. Wilcox that the relevant circumstances justifying list alteration were the stripping out works themselves, my headline response to that is that the circumstances justifying list alteration after the strip out works had taken place were comprised the fact that the property had been placed in a stripped condition. And it was clearly and inevitably a consequence of the fact that the property had been rendered or placed in a stripped out condition that it was capable of beneficial occupation. And those circumstances, again, effectively, however they are characterized, endured until the 23rd of January. And at that point, the circumstances had ceased to exist.
And presumably, you would say it's the same no matter how you characterise it. In other words, if you substituted reconstruction or building works, or however else you would care to describe it, you would say it makes no difference.
My lord, just so. I was going to come to that, but my submission is however you characterise these circumstances, whether you characterise them as the fact that the property had been rendered incapable of beneficial occupation, or the fact that the property had been placed in a stripped out condition, or the fact that the property had been stripped out, or the fact that the property was subject to a reconstruction or refurbishment scheme, in shorthand a monk scheme, it doesn't much matter, because those circumstances, which were plainly matters affecting the physical character of the hereditament, the property, those circumstances came to an end and therefore ceased to exist by and indeed on the 23rd of January.
Well, it doesn't matter at the end of that time whether it was a property which had new wallpaper,
no,
or a property that had a new staircase.
No, it doesn't matter, my lord, because it's the same hereditament, and in any event, the condition of the property or the hereditament, that stage once it's become capable of beneficial occupation once again, after the end date of the MCC, the material change in circumstances, is not a concern of the Valuation Tribunal itself. Rather, it is a concern of the valuation officer and indeed the ratepayer.
Now, could I just put down a request at this stage? I don't want you to do it straight away, but at a convenient moment, I would be grateful if you could take us to the actual proposal in issue in this case. I don't think there's going to be any dispute about this because Mr. Woolcock says in his skeleton argument that what was relied upon was that the property was incapable of beneficial occupation during construction works. But nevertheless, it would be nice to see it in the flesh, as it were.
Yes, well, my lord, I'm perfectly happy to expose the flesh at this point.
Oh, right.
That there are, so to speak, in the core bundle, the proposal itself, my lord. Wrong way. Is on page 65, behind tab 7.
Right.
And in the top left-hand corner, my lord, will see the proposal reference number and the date on which it was lodged.
Right.
If the page is turned to page 66, then in part C, box 16, the detailed reasons for believing that the rating list is inaccurate are set out.
Refurbishment stroke fit outs, including structural alterations, ongoing and incapable of beneficial occupation of offices during construction works. Yeah.
Yes. And then, my lord, I would also emphasise the effectively the second rider to the passage that my lord has read out, where the proposer, the ratepayer, states that the part second and third floors, i.e. the property, are incapable of beneficial occupation as offices during construction works. And the point that I make about that is that effectively what the ratepayer is asserting in box 16 is a mixed quantity of law and fact. So the quantum of fact is that a refurbishment stroke fit out is including structural alterations is ongoing on the date in question, and the quantum of law, which is in a sense also one of fact, but law in the sense that it's material for rating purposes, has to do with the incapacity of the property on that date to be beneficially occupied as offices. And that is that mixed quantity of law and fact is a submission that I'll return to in due course, my lord. But just to see how this point...
Well, you stopped at offices, yes. But in fact it's during construction works.
It does, my lord, it does, just so, during construction works. And that clearly is a reference to effectively the Monk scheme, and express reference is made to Monk itself.
Forgive my ignorance,
yes, no,
but what was the stage of the law after the Upper Tribunal decision in that case? Was it the same as the Supreme Court later decided, or different?
My lord, I believe it was the same. Oh, yeah.
Right.
Yes.
Thank you.
Thank you. And my lord, just to follow up on one matter which is related to this, which has to do with the way that the material change in circumstances and the circumstances, the way that they were characterised before the Upper Tribunal. And it's accepted by my learned friend that the Upper Tribunal had the same vires as the Valuation Tribunal for England, and accordingly was effectively in a position to re-exercise afresh, or, well, to review whether or not the VTE's discretion was appropriately exercised. One moment, forgive me. Page 94 of the bundle behind tab 7 is the appellant's reply. And that is a reply to the valuation officer's statement of case before the Upper Tribunal. And on page 96, paragraph 8. What my learned friend says is that in the instant appeal, the circumstances giving rise to the alteration were the appeal property's loss of the capability for beneficial occupation on the commencement of the works. So effectively the same point was being advanced before the Upper Tribunal as Mr. Wilcox made in response to my Lord's question just before luncheon. And
what do you say about, I mean, the distinction is drawn between the start and the finish of the works.
Yes.
In this analysis.
Yes.
And that unless something else happened, the finish of the works, the appeal property was not a hereditament.
I entirely accept that, my Lord. From the moment at which the property became incapable of beneficial occupation, it could not have been a hereditament in law. But the point is that there later...
but when the property became capable of occupation, again it was a hereditament.
Just so, my Lord. There was effectively a continuum of events in relation to this hereditament during the relevant period, 1st of September to the 23rd of January. On the 1st of September, those events led to the property being incapable of being beneficially occupied. But by the 23rd of January, those events which comprised the scheme of construction meant that those circumstances had ceased to exist, and the new circumstances that existed in place of them were that the property was once again capable of beneficial occupation, and therefore was once again a hereditament.
But was it the same hereditament?
Yes.
Yeah. Despite the physical changes?
Yes, well, my Lord, I forcefully submit that it was the same hereditament, and the changes that took place to the hereditament are agreed matters, and my learned friend took you to them during the course of his submissions. And effectively, clearly, the certain physical characteristics of the hereditament had changed. There was, for example, a new breakout area, a larger, a new reception on the 3rd floor, some panelling designating and dividing meeting rooms, and most importantly, the staircase.
Yes.
And effectively the hole in the roof and then the staircase going down to the floor below. But it was
what is the hereditament in this case? Is it the 2nd and 3rd floors?
Yes. Yes.
As described, address of property.
Yes. Part of the 2nd and the 3rd. And it was possible, effectively, in a cartographic sense, for effectively a line to be drawn around that property. And yes, there were changes, physical changes, so far as the hereditament was concerned, but it was the same unit.
It's occupying the same space.
It's the same space. It is the same space, in my submission. Has the same outline. The cartographer would still draw the rating line around it in the same way that the cartographer would have done on the 22nd of September. So the physical things about the hereditament had changed, but it remained in my submission the same unit of property.
Well, can we just test that a little bit? I mean, I can understand that in one sense if you look at it in terms of the law of real property, it's undoubtedly the same.
Yes.
But is it necessarily the same hereditament for rating purposes? Because one of the changes is that the floor area changed,
Yes.
and that was a key driver in the change in rateable value.
Well, Michael, I will address your question, but the point that needs to be made at this stage is that, in fact, the Upper Tribunal ended up determining that the rateable value had not changed as a result of the removal of 50 square metres in the third floor in order to facilitate the insertion of the new staircase. The only reason that the £1.83 million rateable value could not be backdated to the 24th of January 2015 was because of the effect of the limitation period in Regulation 14. So the 1.83 million RV existed before the scheme of works commenced, and the Upper Tribunal decided that it existed after that as well.
But that's in the, as it were, the second case.
Yes, exactly.
Yeah.
Just so, my lord. But they were prevented and disabled from backdating that rateable value to the appropriate end date, and were restricted to backdating it to the 1st of April 2015 because of the effect of Regulation 14.
Well, I understand that, but can we take that into account, given that at the time of the first appeal, it was agreed that the correct rateable value was 1.8 million, albeit that subsequently we now know that that was falsified.
Well, my lord, I submit that the answer to that is yes, because albeit that those circumstances were not known at the date of the decision of the Valuation Tribunal for England, the first instance tribunal, first tier tribunal, those circumstances were known full well by the time the matter came before the Upper Tribunal, and that is the decision which is subject to the appeal to this court.
It may not lead anywhere, but as a matter of fact, none of the area of the property has disappeared. I mean, square metres don't disappear. They've just chosen to put them on a staircase rather than to put them on somewhere they can put desks.
Yes, just so, my lord.
So that may, of course, affect the rateable value of a property in certain circumstances because it has less desk space.
Yes, my lord, that's absolutely right.
But the actual space in time has not changed at all.
That's absolutely right, my lord. In terms of cubic metres, if one analyses matters in that way, the volume of the hereditament, which extends over
and square metres, actually. If you add up half the staircase and add it to the floor above and half the staircase and add it to the floor below, there's your flat floor.
Yes, effectively before there was 50 square metres worth of concrete and reinforced steel, and afterwards there was a hole in the floor, but there was a kind of semi-vertical staircase.
Yeah.
Yes. Well, I appreciate that I attempted to effectively return your lordship's question with some topspin in relation to the 1.8, the backdating issue, but can I assist further?
Yes, well, I mean, I think we may need to explore this a little more later,
yes.
But you make the point that the true facts, as it were known by the time of the Upper Tribunal, and that might well be relevant if we were considering discretionary considerations. But in the Avison Young appeal, it's a pure question of what is the power.
Yes, that's right. Yes. My lord, I should also just say this, and and this is really by way of foreshadowing submissions which I will come to make in due course. But it is wrong in principle to speak of the power in Regulation 38.7 as if it contains a power to reintroduce or reinstate, or the language that my learned friend used in submissions this morning was put in a rateable value or a hereditament on the day following the day that they determine is the appropriate end date. The true position is that the list is what it is, and the Valuation Tribunal or the Upper Tribunal is not deciding whether or not to put in a new entry on the day after the determined end date. All they are doing is determining when the appropriate end date is, and they are leaving wholly intact the state of the list at all material times after the end date. And that's clearly relevant in terms of my learned friend's arguments about new hereditament or not, because what the Valuation Tribunal is certainly not doing is introducing a new hereditament into the list. They are simply leaving the list in the condition that it is, and effectively which has been either compiled on the list compilation date or subsequently inserted by the valuation officer or by the Valuation Tribunal.
Right, so let me state that point in a completely different way, just in order to check that I've understood it.
Yes.
Do I understand that what you're saying is that we need to distinguish between, on the one hand, the hereditament, the property, being incapable of occupation and therefore not being a hereditament during the period of the works? That's one thing. And on the other hand, the change in the rateable value that's occurred as a result of the works.
Yes.
Which is something different.
It's something different. Certainly on the fact of this case, it's something different because of the way the proposal was framed. Theoretically would be possible for a valuation tribunal to deal with two proposals dealing with those two matters, and could deal with those matters effectively in a composite way.
Yeah.
But that is not what the facts are here. So yes, my lord, I would answer in the affirmative to your lordship's question, which is that, and it effectively is a point to do with scope of proposal. If the scope of the proposal seeks either the deletion of a hereditament during the currency of a monk scheme of works, or, as here, its reduction to a nominal value during the currency of a monk scheme of works, then it is absolutely not for the Valuation Tribunal to concern itself with what the correctness is of the rateable value, and therefore the accuracy of the list itself on the day after the end date of the relevant circumstances.
But at that moment, either side can start a process in order to set the level at what might be a new.
My lord, that's exactly the point that I was about to make, which is effectively that the existence of an inaccuracy on the day after a Reg 38.7 end date is a perfectly good and sound reason for a ratepayer to make a proposal to protect its position. And indeed, I would fully accept, is also a very good and sound reason for the valuation officer to seek to unilaterally alter the list. But certainly is not a good reason, in my respectful submission, to say that the Valuation Tribunal itself does not have the vires to end date an MCC proposal. that sort of brings me to my second headline point, which is to the extent that an inaccuracy persists after the period in respect of which a Regulation 38.7 order is made, the persistence of that inaccuracy is not because of the tribunal's exercise of its discretion under Regulation 38.7. That causal link is not present. The inaccuracy persists because the list is in that condition or that state, and has been put in that position by previous conduct of the valuation officer, either at list compilation date or for any other reason.
Well, I'm a bit puzzled by that way of putting it. Would it not be more accurate to say that the inaccuracy persists because, firstly, there's been a change to the state of the property, and secondly, no one has yet taken steps to change the list in consequence?
My lord, I adopt that submission, but it reinforces the sort of headline submission that I made, which is that the inaccuracy certainly does not persist because of any manner in which the Valuation Tribunal itself exercises its discretion under Regulation 38.7. And in fact, in a case such as the present, if the Valuation Tribunal declined to exercise its Regulation 38.7 discretion, then there would be a causal link between the exercise of power by the tribunal and the inaccuracy of the list. Because the true rateable value of the hereditament on the day after the end date would be, on these facts, 1.83 million. But if the tribunal declined to exercise its Regulation 38.7 power, then that value would be removed from the list by dint of the order of the tribunal.
Could I just ask you
Of course, my lord.
something which may be completely off the wall, but it's the wording of sub 7.
Yes.
The tribunal's order can require the alteration to be made in respect of such period as appears to it to reflect the duration of the circumstances.
Yes.
I don't suppose there's the opportunity for it simply to give an extra day to the ratepayer.
No.
In order that they shouldn't be out of pocket.
My lord, no. I'll come to develop the submission in just a moment, but my submission is that, contrary to what my learned friend Mr. Wilcox submits, the power in Regulation 38.7 is actually relatively narrow. The discretion is binary, i.e. should the tribunal exercise or not the discretion. But the discretion can only be exercised in relation to the period that reflects the circumstances.
So that's the focus, and my suggestion would offend against your principle, which is that the actual correct valuation and the period of abatement, or whatever it is, are two separate matters.
Yes. Yes, my lord, exactly. It would effectively involve the tribunal trespassing on matters
Yes.
which were not subject to the scope of, or within the scope of the proposal. Effectively, what my learned friend's submissions amount to, it is a submission that wherever there is found to be a list inaccuracy after the relevant period, then the tribunal is in effect obliged to exercise its discretion in a way that removes a ratepayer's liability to pay tax based on an inaccuracy of the list. And that in my submission is a bold argument. because the argument would apply even if the inaccuracy is small, such as in this case, and beyond the scope of the proposal, and in circumstances where both the ratepayer and the valuation officer, effectively in normal circumstances, if one strips away the limitation matters, both the ratepayer and the valuation officer have the opportunity to do something about the inaccuracy. So, my Lord, those are my headline submissions, and I'll focus in and circle back on some of the points I've made. And just by way of signposting, the first head of my submissions will deal with Regulation 38.7 itself, the language used. I then, if I may, will make some observations about the scope of that power in the broader statutory context. I'll then identify what, forgive me, I submit is the purpose of Regulation 38.7. And then identify what the circumstances were in this case that gave rise to the alterations ordered by the VT, and I've largely touched on that. And then finally deal with the arguments that Mr. Wilcox takes against me, effectively.
Could you at some point in your submissions address us a little further on the question of limitation? Because as I understand it at the moment, it's common ground that the situation that arises in both of these cases is, for want of a better word, because I can't think of one just at the moment, an artificial one, in that it's driven by limitation. And so, because of that, I think I would certainly find it of assistance to understand the limitation provisions a little better than I currently do. But also, I would be interested in your help on this question. To what extent, in construing Regulation 38.7, is it legitimate to take limitation into account? Ought one instead, perhaps, to construe Regulation 38.7 in what one might call a limitation-neutral way?
Yes. My Lord, I certainly can address you on the mechanics of Regulation 14, which contains the limitation provisions, and I'll do so when I make observations about the scope of the power in its statutory context. But just to answer effectively the query posed in my Lord's question, I would absolutely agree that so far as interpreting the scope of the power in Regulation 38.7 in principle, bearing in mind that the power is discretionary and not mandatory, the appropriate approach is to do so in effectively, as my Lord described, a limitation-free bubble. It may well be relevant when it comes to a tribunal's exercise of discretion in a particular case.
Yeah.
The limitation period for either the ratepayer making a proposal to rectify matters, or the limitation period for both the ratepayer and the valuation officer has expired.
Yes, so in other words, your submission is that limitation is a factor that bears upon the exercise of the discretion, not on the scope of the power.
Yes, yes. And my Lord, one can well conceive of a situation in which the hardness or harshness of the operation of the limitation regime in a particular case was regarded as a weighty consideration by a tribunal when it came to exercising its discretion. But it's difficult to see how the scope of the power itself in Regulation 38.7, which I'll come to now, depends on the operation of the mechanics of the limitation regime, which obviously will be different on the facts of every case that comes before the tribunal by way of an appeal.
Yeah. I mean, that would tally with what one, I think, would normally take to be the effect of limitation, which is it is a, so to speak, an external constraint which is applied to some otherwise pre-existing cause of action.
Yes.
It's not, and it rather puts the matter the wrong way around to let the limitation tail wag the, as it were, construction
I agree.
dog.
My lord, yes, I agree. So if I may, I'll turn to Regulation 38.7 itself. And my lords may have this, well, do have this in a number of different places in the documentation, but behind tab 7 it is where perhaps I would invite my lords to turn if convenient. There's no internal pagination, but it in sort of relatively and somewhat unhelpfully grey numbering, there is a number 3 at the bottom of the page, and that's where I am, about halfway up. And their Regulation 7 is set out. What it provides is that where it appears to the tribunal that circumstances giving rise to an alteration ordered by the tribunal have ceased to exist, the order may require the alteration to be made in respect of such period as appears to the VT of the tribunal to reflect the duration of those circumstances. There are, in my submission, 3 matters to unpack so far as the first part of the regulation and the provision is concerned. Namely, where it appears that the circumstances giving rise to an alteration by ordered by the VT have ceased to exist. The first point to note is, well, the very first point to note, as my lords will be well aware, is that the power is discretionary, but only becomes available where it appears that the circumstances giving rise to an alteration ordered by the VTE have ceased to exist. And there are effectively, in my submission, 3 elements in that passage, or that clause. The first is that there is, or perhaps more accurately, is going to be, as a result of the way that the tribunal has determined the appeal, an alteration to the list ordered by the VTE. And what that means in effect is that before the power can be exercised, the tribunal have to have found that an appeal before them was well-founded or is well-founded, and proposed to order the valuation officer to alter the list in the manner contemplated by the proposal that gave rise to the appeal. Second, that alteration will always, and indeed can only be justified by what is, in the language of Regulation 38.7, circumstances. So in effect, in the provision, the word circumstances is being used to describe or signify whatever it is that gives rise to the list alteration, or the proposed list alteration at the point of the decision having been made. And that is the work that the word circumstances is doing. And I submit that to seek to give the word, which is here, clearly being used in a plain and ordinary sense, a more technical meaning, as contended for by my learned friend, it is wrong and clearly is not what is contemplated by the draftsman, and is not consistent with the role that the word circumstances is playing in the mechanics and the structure of the provision. It's only referring to whatever it is that gives rise to the justification for list alteration. And my lords, it's not without relevance, I submit, that the draftsman has used the word circumstances as opposed to circumstance. And it may not be a major point, but the draftsman has used the plural and not the singular. And I submit that the reason for that, which I touched on at the outset of my submissions, is that ordinarily the circumstances justifying the alteration of a list will be a mixed quantity of law and fact. So, for example, in a split hereditament case, there will be the basic facts. For example, the letting of part of a hereditament to another owner, as in the Crooked Spaniard case. And then the legal consequence of that is that there has been a split of hereditaments. Or in a reduction in rateable value case, there will be a set of primary facts. For example, roadworks adjacent to the relevant hereditament. And there will then be the consequences of that, which will be that the rateable value is reduced because a notional tenant would only be prepared to pay a lower amount to secure a yearly tenancy of the hereditament.
Well, if we're paying close attention to the language, as I think you're suggesting we should,
Yes.
do you submit that there's any significance in the fact that the definite article is not used? It doesn't say where it appears that the circumstances giving rise to an alteration have ceased to exist. It says where it appears that circumstances
Yes.
have ceased to exist.
Yes. My Lord,
Could be some, not all.
yes, it could. Indeed, it's clearly a less hard-edged way of formulating the provision than the draftsman could have selected or chosen. But my submission in relation to the word circumstances, that it's apt to embrace this mixed quantity of law and fact that will give rise to an alteration ordered by the VTE. And I'll develop that argument slightly more detail when I address Mr. Wilcox's contention that a distinction is to be drawn between causes and consequences. And in my submission, they are effectively both of those matters. Firstly, very difficult to draw a conceptual distinction between the two. And secondly, in any event, both are circumstances. And I certainly don't mean this to be a jury point, but throughout my learned friend's submissions this morning, and in his skeleton argument, he consistently uses the word circumstance. And that apparently simple semantic sleight of hand, which cuts down the plural which is actually used in the legislation to a singular, is the foundation for my learned friend's submission that the VTE is confined to identifying exclusively one circumstance. Thirdly, my lords, there is a requirement for those circumstances to have ceased to exist by the time of the tribunal decision. And again, that is, those words articulate a condition precedent to the existence of the power, such that if whatever the circumstances are that justify list alteration on the fact of the matter in hand, if they have not ceased to exist, then the power cannot be exercised at all, and there is no discretion to do anything other than order effectively a permanent list alteration. And that is the case even if, for example, there is agreement as to when the circumstances will come to cease to exist in the future. So that could well be the case in relation to the date on which a lease determines. For example, it may be perfectly obvious that a hereditament which was split by way or by dint of the execution of a lease in relation to a property would come to an end on the date at which a lease determined. or, for example, if there was a contract under which the leaseholder of part of a building was to acquire freehold title to the whole building, such that on the date that that contract completed, there would be a unity of title, for example. But the discretionary power in Regulation 38.7 is only available where there is no evidential uncertainty about past events as opposed to future events. And clearly, in my submission, the tribunal is well placed and is able to receive evidence on when the date was in the past that these circumstances ceased to exist. So what this means, my submission, is that discretion on the part of the tribunal exists only where the position on the date of the tribunal decision is that the tribunal can look backwards in time and identify the date on which the circumstances giving rise to a list alteration have ceased to exist, such that there is a clear and certain candidate period in respect of which the tribunal's discretion is engaged. And my Lord, this goes to the point that my Lord raised earlier in relation to, well, can they kind of cut it and give an extra day here or there? They can't. There can only be one candidate period.
Can I ask a completely different question, which is, and in a sense, to some extent, I'm foreshadowing perhaps your third subject. In that case, I apologise. But one wonders why bother to have this regulation at all, or this paragraph of this regulation at all, because one might have thought one would naturally assume that the tribunal would have such a power anyway.
Yes.
Why do we need this paragraph?
Well, I suppose, my Lord, technically the reason is because the Valuation Tribunal and the Upper Tribunal as a statutory body can only exercise statutory powers. So effectively the draftsman is making it perfectly clear that the power exists.
The regulation presupposes that you can have circumstances justifying an alteration which only exist for a period of time.
Yes.
And one might have thought the most natural thing in the world
Yes.
is for any alteration to reflect that.
Yes, well, that would be effectively what my submission is. And that there will be many MCC proposal cases or deletion cases where it's perfectly obvious by the date of the tribunal decision that those circumstances have ceased to exist, come to an end.
All right, but where does that lead to us in terms of interpretation? If one takes the view that this is, as it were, a for the avoidance of doubt provision, to put it beyond doubt,
yes,
that the tribunal has the power to do this in appropriate circumstances, where does that take us to in terms of interpreting the scope of the power?
Yes, that's what I was about to come to. The submission that I was going to rest on effectively that peg is that the requirement for there to be backwards looking or rear facing evidential certainty as to what I referred to a moment ago as the candidate period means that the scope of the discretion in Regulation 38.7 is in fact relatively narrow and does provide for the certainty that my learned friend effectively has quite rightly said is a very important consideration in any context, but most particularly in the taxation context.
Is sub 7 following on from subsection 4?
Yes.
So
It is, my lord.
a requirement on the officer to alter the list.
Yes, my lord, and I was going to come to that. it's important to note that it's technically not the tribunal itself that alters the list. Rather, it effectively issues a mandatory direction to the valuation officer to alter the list. And just to kind of top and tail that point, if my lords go to section 55 of the 1988 Act, which is behind tab 1, and I'll provide a page reference. My lord, it's on page 20 of the I think it's like a Westlaw printout, or yeah, it's something like Westlaw printout. So there's a fairly faint page 20 in the bottom right of the page. So it's section 55. Subsection 6. This is the section in the 1988 Act that Mr. Wilcox described as the foundation for the regulations that came to be made in 2009, the Arnold regulations, and effectively provides, it provides powers on the part of the Secretary of State to make delegated legislation dealing with these matters. And the only point that I was going to point out to my lords was Regulation 6, subsection 6A provides expressly that regulations may include provision as to the period for which an alteration of a list is to have effect, or the day from which an alteration of a list is to have effect. So it doesn't take matters particularly far in the sense that that just leads one into the regulations themselves, but perhaps not without relevance that the Parent Act itself contemplates that delegated legislation is able to make provision either for amendment of lists for periods or, as my learned friend suggested, was the kind of default position for days. So as to the meaning of cease to exist, those are words which are used in relation to the word circumstances. So it is the circumstances that must have ceased to exist by the date of the tribunal decision. And my submission is that these are ordinary English words with clear and straightforward meanings, and is being used in the legislation to connote a state of affairs in which whatever the circumstances are that gave rise to the list alteration are no longer present on the day of the tribunal decision, such that it is apt to say that they have ceased to exist. And as I said set out in my skeleton argument, the sense of the phrase, or the term ceased to exist, it is also capable of being conveyed by the words cease to pertain or cease to subsist. But I make it abundantly clear, my lords, that it is not my case that those terms should be imported into the provision. I simply articulate them by way, or effectively as useful analogues to cease to exist. But what is important is that the circumstances are no longer physically observable on the date of the tribunal decision. And my learned friend has pointed to the Merlin case and also Chiltern Merriweather, and he says, oh, well, what one is concerned with is matters affecting the physical fabric of the hereditament or the locality. And I entirely accept that. But that does not do any damage to my argument.
Do we know when this provision first came into the relevant legislation and whether it was can it be traced back to any particular problem or mischief that was perceived, or is it really just there, and we have to make the best of it we can in its context?
Yes, my Lord, I believe it's the latter. Regulation 38.7 wasn't introduced into the 2009 regulations after they were originally enacted.
Mm. What about predecessor regulations? I mean, did it have an...
My Lord,
and I'm not asking for an archaeology exercise if it's not going to lead anywhere. I'm just really curious.
Yes, no, I've...
Because I think I gather from what we're told about this case that on the whole it's rather languished in obscurity until it was the rather unusual backlog of...
Exactly.
Which gave rise to limitation problems, which raised the question whether this could be used as a kind of alternative way to achieve a sensible-looking result.
My Lord, yes, effectively that is the position.
Yeah.
Except that I certainly wouldn't accept the contention that the valuation officer was urging on the tribunal a course of action which was anything other than perfectly ordinary in the context of what Regulation 38.7 means. Of course, it just so happened that on the day after the end date, there was no scope either for the ratepayer or the valuation officer to go back and to change the rateable value. But again, that comes back to the discretion and the limitation point.
Isn't there a clear pattern? When you've taken us to section 55.6, which is the from which and for which subsection.
Yes.
And we find that in regulation 38 has both a from which and a for which echo in them. I mean, the sub 7 is the for which period, the length of the period for which. But one would also be concerned with a situation which was a simple from which,
yes,
where it wasn't, where there'd just been a change.
Yes, that's Regulation 38.4, my Lord.
Yes, and indeed, from which appears in 5 as well. So the regulation
it does, yes.
is taking up the alternatives that were presented in the statute.
That's exactly what my point was in relation to section 55. What Mr. Wilcox says is that circumstances cannot cease to exist if in fact what happens is that the relevant circumstances are superseded by a different event or different and later event. In my submission, though, that is a misguided argument. And in fact, an event or circumstances can only come to an end if they are superseded by the occurrence of a later event or sequence of events. Effectively, I mean, perhaps this is an ontological indulgence, but you effectively will, you have events which comprise circumstances, and when you do, you have the coming into existence of circumstances. And in order for those circumstances to cease to exist or come to an end, or however one wants to put it, something else has to happen.
But Mr. Wilcox's end is in his beginning. The thing begins and ends.
Well,
at the same time.
Well, yes. Well, that's the problem with his argument in a sense, because what he says focuses very narrowly on the stripping out works. He says the events were, or in his language, the circumstance was the stripping out works. And my primary response to that is, well, you've got to look one stage after that, and actually the circumstances were the fact that the property was in a stripped out state. But But even if you say that the circumstance was the stripping out works, that circumstance ceased to exist when effectively other events along the continuum of the works took place, such that the property was no longer stripped out. And again, I mean, Mr. Wilcox fairly accepted that in a scaffolding kind of case, you would have an event or a circumstance which ceased to exist. But with respect, it's difficult to square that submission with what he submits about the present case, because where scaffolding goes up, the erection of the scaffolding itself doesn't cease to exist. The scaffolding itself certainly doesn't cease to exist. It's effectively another event happens, which comprises the removal of the scaffolding and the removal of the scaffolding from the building somewhere else. So the end can't be the beginning, because one is and can only be concerned with effectively a process of events, a sequence of events. At the beginning, something happens which comprises circumstances justifying a list alteration, and then something else happens which mean that those circumstances have ceased to exist.
But as I understand your submission, the beginning identifies the beginning and the end identifies the end.
Yes. Yes,
And it's as simple as that.
It really is as simple as that. It really is. Well, my lords, the next clause, I don't apprehend to spend much time dealing with it, but the next clause in Regulation 38.7 provides that the order made by the tribunal effectively disposing of the appeal may require the alteration to be made in respect of such period as appears to the tribunal to reflect the duration of those circumstances. And I say, I don't apprehend there to be any dispute about the meaning or the functionality of that provision.
Coming back to the question I asked earlier, might one view of the purpose of this be to ensure that the tribunal actually has a discretion not to do it?
That must
Because
follow.
it might be suggested that in the absence of the word may here, if you assume that this provision didn't appear at all, one would naturally suppose that if the circumstances endured only for a certain period of time, then the alteration must be limited to that. Whereas what this tells us is that it may be limited to that. In other words, it may not.
Yes, that must follow, my lord. Yes, that must follow. And there's clearly a continuum in relation to what the draftsman could have enacted. They could have said, may not require the alteration to be made in respect of a period. On the other hand, they could have said, the order must require the alteration in respect of a period, and the draftsman's taken the middle way. And it must follow that there is a discretion that in case A will pull one way, and in case B may well pull another way. But I emphasise that those are not, effectively, the discretionary elements of this case are not challenged by Mr. Wilcox. But what's to note here is that the word circumstances is used again, those circumstances. And again, don't take it to be a disputed matter that circumstances here has the same meaning as earlier in the provision. And I've already made the point in response to questions that the discretion is a narrow one in my submission, not a broad one, so far as what the discretion relates to. The discretion, whether or not it's exercised, can only relate to the period, such period as appears to reflect the duration of those circumstances. And that is an important consideration when it comes to my learned friend's submission that the power needs to be interpreted narrowly. Well, in my submission, it's already narrow. factors that feed into the discretion in any individual case will effectively be what they are in the real world, and that's effectively the breadth of the material considerations that are capable of feeding into a discretion cannot be an argument for reading down the scope of the discretion in principle, which in any event I say is a narrow one.
So you say it's a small tool, but
Yes.
you can take everything into account in deciding whether to use
Yes.
it, and if so, how.
Yes, and I say that if Parliament had intended to exclude, to effectively to render certain considerations immaterial for the purposes of discretion, then they would have needed to say so. So any fact about the real world which are known to the tribunal on the date of the decision are capable, it seems to me, on principle, are capable of feeding into the discretion, but the discretion can only be exercised in relation to that particular, what I referred to previously as the candidate period, which is one in relation to which there is no evidential uncertainty, and as I've already said, can only be backward-looking and not forward-looking. The last point I was going to make about Regulation 38.7 is one that I've trailed already, which is that it's incorrect both conceptually and linguistically to speak of the reinstatement or the restoration or of putting back in entries in the list. The list already contains the entry for the relevant day, and Regulation 38.7 only allows, or simply, as my Lord said, allows the tribunal to alter the list for a period, temporarily in other words. And at the end of that period, the list stands, and the entry is not reintroduced into the list.
Can you help us at some point about the distinction drawn in Monk paragraph 31?
My Lord, I think I ought to deal with that now, because I took instructions on it over the adjournment. Those instructing me said that the reason why that practice was initiated in the first place was because they had received at some point legal advice to the effect that that was the proper course of action. And as Mr. Wilcox said, there was a certain, and I believe that the Supreme Court reflected this, and certainly the Upper Tribunal did in Canary Wharf, but it came then to be seen as a matter which was administratively rather convenient, because effectively left a footprint on the list which could be periodically checked to see whether that building undergoing reconstruction was, effectively a phrase that could be seen and had that kind of signature on the list itself, and periodically the valuation officer could go back and check whether matters had moved on or advanced in relation to a particular building under reconstruction hereditament. But indeed, as Mr. Wilcox submitted to your lordships, that practice has now effectively been abandoned.
If a property is removed from the rating list as a preference, and then it's put back on again, it's as if it was just back on again as it last appeared. Is that right?
Well, my Lord, it may well be right on the facts of a particular case. It depends what it was put back on as. But as I said, the power in Regulation 38.7 is only to effectively alter the list until whatever the end date is. So there's no question of an entry being put back onto the list by way of a Reg 38.7 order.
Well, can I ask a different question
Yes.
on this topic? The inference I'm drawing from what you and Mr. Wilcox have told us is that, contrary to what one might have thought when reading paragraph 31 of Monk, is that there is no relevant constraint upon entering a hereditament on a list.
Yes. My lord, yes, it's an unusual one, because a hereditament has to be capable of beneficial occupation. So a hereditament that is not capable of beneficial occupation is not a hereditament. It's a unit of property.
Yeah, that the Supreme Court have confirmed.
Exactly. And it's therefore a paradox to have a hereditament with a nil or a nominal rateable value, effectively, because a hereditament has to be capable of beneficial occupation, it has to be able to command more than a nominal value in the rating hypothesis. So, as I understand matters, what the Supreme Court said in Monk was that for administrative convenience, instead of removing the entry from the list altogether, one could put an entry on the list for a building under reconstruction with a nil or a £1, i.e. a nominal rateable value, which effectively had the same substantive outcome, because in one case you've got a unit of property which is not a hereditament.
Yeah, but the question goes to why is it, or why was it regarded as administratively, as a useful practice? And the answer is, I think, is common ground, is only because it was thought to be administratively convenient, not because there was actually any constraint that would prevent one from deleting and then putting in a fresh entry.
My lord, yes. Yeah. And as a rider to that, I do accept that it's possible for a deletion to be ordered by the tribunal in response to an MCC proposal, as well as, obviously, a deletion proposal. I'm not sure whether that takes it any further particularly.
Well, it clarifies a mystery, so far as I'm concerned, so to that extent it's helpful.
One of many mysteries in the present case, my lord. I'm grateful. So the last point that I wanted, if I may, to make about Regulation 38.7 it is effectively by way of response to Mr. Wilcox's submissions, which he grounds in the proposition that if you look at the regulations and the scheme of the Act, it is full of prospective provisions and positions and provisions which protect a ratepayer from, for example, retrospective increases in rateable value. And those arguments do not assist Mr. Wilcox in this case, in my submission, for the simple reason that the inaccuracy on the list that Mr. Wilcox's clients can point to on the day after the end date has not been caused or introduced, and is incapable of being caused or introduced by the exercise of the power in Regulation 38.7. So there's effectively nothing for the protective machinery of the legislative framework to bite onto in a case where the tribunal looks at circumstances that justify list alteration, knows exactly when they finish, knows or determines exactly when they finish, and decides to effectively end cap or end date a proposal so that it terminates, so that the list is only altered for that period.
The inaccuracy is caused by the failure of either party to take steps to create perfect accuracy. My lord, yes.
The inaccuracy is caused because there is an entry in the list in respect of which no party has taken action at whatever the relevant date is. And that's why I said at the outset that normally, and this is a matter that I submit would go to discretion, normally if if a tribunal exercises its Regulation 38(7) power to end date to provide for a alteration of the list for a duration, for a period, then that will normally, and then it's obvious that the day after that period comes to an end, there's an inaccuracy. That will normally be a perfectly good, proper and sound reason for either party to take action. But it is, as I said again at the outset, it is the existence of an inaccuracy on the list the day after a Regulation 38(7) period comes to an end cannot, in my submission, extinguish the vires itself under Regulation 38(7) to make an order that reflects the duration of the relevant period.
But to put things the other way around, if in a case of this sort, for reasons that seem good to the valuation officer, he had pursued across years the recovery of a couple of £1,000 in the circumstances of this case, the tribunal might not be very impressed about that.
Well,
and might decide not to exercise it.
Well, my lord, actually the answer is no to that, specifically because there is a separation under the scheme of the 1988 Act between the valuation officer, whose only function is to maintain the list, and the billing authority, which is effectively, in most cases, analogous to, in terms of local lists anyway, is normally the district council for the relevant area. And there are provisions for effectively, in that situation, it would be possible for repayments to be not just made, but in fact ordered.
Yeah, and there's a whole complicated set of statutory provisions dealing with that, as I know to my cost.
Yes, there is, and indeed it's not in the authorities bundle, but Schedule 11 of the 1988 Act, which provides certain, again, enabling powers to this, enables the Secretary of State to make delegated legislation dealing with clawback in that position. So, I mean, again, I wouldn't, my lord, want to submit to you, and I don't submit to you, that a consideration of that nature could not be relevant, public law terms, to the exercise of discretion under 38(7), albeit that I would submit that it would be most unlikely for it to be a weighty consideration given the existence of the clawback and repayment provisions. So I'll move, if I may, to the legislative context, and I think I need to refer my lords to Regulation 4. This is a matter that may be common ground at this stage, but behind tab 5 in the authorities bundle, Regulation 4 of the alteration regulations sets out the grounds on which proposals are capable of being made. And for present purposes, the relevant proposal was a Ground B proposal. Material change of circumstances. And a material change of circumstances is in fact a defined term under the legislation. And forgive me, I should have referred my lords to tab 3 of the bundle, not tab 5. But page 14, I believe, of the bundle as a whole, but Regulation 3, which contains the interpretive provisions for Part 2, defines a material change of circumstances as a change in any of the matters mentioned in subparagraph 7 of paragraph 2 of Schedule 6. Those are the reality factors, and they can be seen behind tab 1, again on grey internal page 29. And for present purposes, it's sufficient, my lords, to note that subparagraph A is matters affecting the physical state or physical enjoyment of the hereditament. And I submit that what is to be gleaned from paragraph 2.7 is that there is clearly some nexus between what are described as matters in paragraph 7 and circumstances in regulation 38.7. But the use of but effectively the use of the word circumstances in regulation 38.7 and in the definition of material change in circumstances clearly does not mean that the power is only capable of being used in the context of a ground B proposal. So to summarise, perhaps I haven't articulated the point very well, but I accept that there is a nexus between matters and circumstances. But the statute and the legislation does use different words in the different provisions, and it cannot be said that circumstances are entirely and universally analogous to matters. And that picks up on one of the interventions made earlier.
I mean, they're both words of exceptional generality, aren't they?
They
Both matters and circumstances. So we'll need a fairly strong context to persuade one. I would have thought that one has to construe the apparently entirely general reference to circumstances in 38.7 as somehow narrowly focusing on matters, in paragraph 2.7, whatever it is, of the 1988 Act.
I would entirely agree with that, and that's effectively why I do not urge that submission on my lords.
Yeah, thank you.
Section, forgive me, it's not section, it's regulation 35 of the Council of the Appeals Procedure Regulations is the provision that deals with consent orders. And I just need to deal with this very quickly because a point taken against me, and this is behind divider 7 of the authorities bundle, my lords. I'll just paragraph 1 of regulation 35 and paragraph 2 effectively makes provision for consent orders to be made by the tribunal, and I emphasise that paragraph 1 is effectively a very broad provision. And my argument that I've advanced in my skeleton argument is that there is two parts to it. One is that under regulation 35, a consent order could end date an MCC or a deletion proposal. I don't understand that to be contested. And what is said again, and the second part to my argument is that, well, if it's the case that a consent order could do that, then there's no good reason why the tribunal couldn't do that itself under regulation 38.7. There's effectively no good reason why the Valuation Tribunal would have a more restricted power in regulation 38, both on paragraph 4 and paragraph 7. Than they do under regulation 35. And what Mr. Wilcox says is that actually if you look at the scheme for under regulation 12 of the ALA regulations, that actually a valuation officer is able to agree to matters which are beyond the scope of a proposal before an appeal either is made or deemed to be made. And the simple response that I submit to my lords to that submission is that the reason why there is a difference between the scope of the power in regulation 12 and regulation 35 is that under regulation 12 the valuation officer simply is quite clearly enabled to do something which goes beyond the scope of the proposal. Effectively expressly says so, but that's because he could do so anyway by way of making a unilateral alteration to the list. So under Regulation 12, the valuation officer is given the express power to do something compendiously and in a composite way that he could achieve, that he could do in any event. Whereas when matters become appeals under regulation, and an order is made either under Regulation 35 or Regulation 38, the tribunal, and my learned friend has taken my lords to the case law on this, but a tribunal is strictly limited to the scope of the proposal. So I do say that if it is the case, and I submit that it clearly is the case, that a consent order, which has to be approved and effectively made by the tribunal under Regulation 35, could end date an MCC or a deletion proposal, then it clearly can do so under Regulation 38.7 as well. My lords, I apprehend that I'm sort of at the end of my the estimate that I had originally given to my lords, but I do have a bit of material yet to cover. I don't anticipate that I'll need more than another 15 minutes with a fair wind, or perhaps 20. Would that be acceptable to my lords?
Well, it's really a matter of the knock-on effect on everyone else's time.
It is,
really,
indeed.
given that this case is listed for a day and a half.
Yes. I think probably the best thing for me to do is just to be as quick as I can now. The last time I looked at the schedule, there appeared to be a bit of spare time. Obviously, I don't want to kind of monopolise any slack in the schedule.
I'm inclined to say we'll allow you 15 minutes.
Yes, my lord. I was going to say I'll absolutely finish within 15
no
minutes.
more than that, and then see where we are as the hearing progresses.
Yes, my lord. I'll keep a very, very close eye on the time and seek to be as expeditious as I can. Just take so far as the legislative scheme is concerned, just necessary to point out that the obligation in the Act to maintain list accuracy is imposed on the valuation officer as opposed to on the valuation tribunal itself. There is no duty analogous to subsection 1 of section 41 on the tribunal as such. It might not seem like an important point, but in my submission it does have some materiality, because while clearly the valuation officer is expected to maintain the list in an accurate state as possible, the function of the valuation tribunal is somewhat different, because the valuation tribunal has the function of determining the soundness of any appeal that comes before it. So it is strictly concerned with the accuracy of a proposal that comes before it by way of an appeal, as opposed to having an overarching duty to maintain the accuracy of the list as a whole. And all that point goes to is one, which is a point that I've already submitted, which is that there is no scope under Regulation 38.7 to do anything other than that which is already in the scope of the proposal, which is effectively to end date a list alteration. But it also, in my submission, goes to the point of, well, what is the significance of the fact that after a proposed end date, the list is in an inaccurate position? In my submission, that, again, have made this submission, but that is not a matter that the valuation tribunal is effectively or that effectively removes the vires of the tribunal itself. And I pose the rhetorical question, why should the fact that the list would be inaccurate in and of itself mean that the tribunal has no power to make the list as accurate as it possibly can be for the proposal which is actually before it for adjudication? I think I can deal very briefly with the purpose of Regulation 38.7, and I needn't say no more than this, that self-evidently the purpose of Regulation 38.7 is to enable the tribunal to make time-limited alterations to the list where the circumstances giving rise to the list alteration are themselves time-limited. And I submit that the language used in Regulation 38.7 should be interpreted in accordance with that purpose.
And in effect, you're deriving that purpose from the wording of the provision itself.
I am.
Even if it's very often
Exactly.
the best one can do.
Yes, absolutely, my lord. So I'll turn now to identifying what these circumstances were in this case. And in doing so, I want to deal with the distinction that Mr. Wilcox makes between causes and consequences, which I say is unsound. Firstly, because it's not a distinction which is drawn in the context of the legislation itself, which only uses the word circumstances, but also conceptually is an unsound distinction, because often causes can be consequences and vice versa. And I'll show that by this case, in fact, is a very good example of that, because effectively the primary facts here are that stripping out works took place in September of 2014, and at least 3 consequences arose as a result of that. Firstly, the property came to be in a stripped out state or condition. Secondly, the property was unable to be beneficially occupied. And thirdly, the property was not a hereditament as a result. So although Mr. Wilcox says that as soon as you move beyond the primary set of facts, what you're dealing with is consequences, in my submission, that it is unsound, and actually you effectively you just get to the next kind of point in the chain of causation. So anything that can be described as circumstances can equally be described as causes. So, for example, the fact that the property is not a hereditament was caused by the fact that the property was incapable of beneficial occupation. So far as circumstances are concerned, it cannot just be the primary set of facts, which, as I understand it, Mr. Wilcox relies on to an extent, i.e. the taking place of the stripping out works between date X and date Y. Because if you look just at the primary set of facts, that tells you nothing about what the list alteration could and should be. For example, whether it should be a deletion or a merger or a split or a reduction or indeed an increase in rateable value. So you effectively have to assimilate and have regard to an extra bit or unit of information before it's possible to decide whether an alteration is justified, and in effect before there can be circumstances giving rise to a list alteration. And that picks up on the point that I made at the beginning of my submissions, where I said and submitted to my lords that circumstances is apt to describe a quantity of mixed fact and law. So here, the circumstances are either all or any of any combination of the following: either the fact that strip out works had occurred, or the fact that the property had been placed in a stripped out condition following those works, or that, indeed, as I said, or that, slightly different angle is that a scheme of works was taking place and had rendered the property incapable of beneficial occupation, and therefore that the property was not a hereditament. It's that basket of causes and consequences and primary facts which all comprise, in my mission, circumstances. And clearly, on any view, those circumstances ceased to exist on the 23rd of January, because on that day, the scheme of works had progressed, the property was no longer in a stripped out condition, the property was capable of beneficial occupation, and therefore was a hereditament. So the final matter that I was going to address my lords on, and these are thankfully all matters which I have dealt with in my skeleton argument, are those advanced by Mr. Wilcox. And the first is the distinction between continuous or ongoing against one-off events. And I've already submitted to my lords, I made the point that events are not susceptible of being characterised in that way. Effectively, always and only can ever have a process. Technical and non-technical approaches to construction. I simply echo the point that I make in my skeleton argument that I do not accept that my approach is a non-technical approach and that Mr. Wilcox is advancing a technical interpretation. There is effectively no candidate interpretation of the regulations which can truly be characterised as a technical interpretation, and nothing in the cases that Mr. Wilcox refers to gainsays the position that I have sought to set out, because there simply aren't competing technical against non-technical interpretations in any event. And so then I think the final matter that I need to deal with concerns the new physical characteristics of the hereditament and what Mr. Wilcox characterises the ABA against ABC situation. And I've made the point already that in my submission doesn't arise in the present case because it was the same hereditament. In my submission, this is a matter that classically would go to whether or not the tribunal ought to exercise its discretion in any particular case, and it cannot be
your thesis is that it's just AB.
Well, no, my lord. Mine is that it's ABA, because it was effectively A being the state of the hereditament before the scheme of works. And then B is when it was no longer... Yes,
but so far as the tribunal is concerned, it's not concerned with what happens after B. It just decides that B has come to an end and that's it.
Very much so.
So for the tribunal is a two-stage,
yes,
you say, and argument about whether it should then be A or C
my lord has the point.
Is for another day and another process.
My lord, that's exactly the point that I was going to make. Yes. And linked to that point is the practicalities of the operation of Regulation 38.7. Effectively, if one puts aside the limitation positions, in terms of limitation, it just is the case that as a result of the existence of limitation provisions, wherever they arise in whatever statutory context, there will be cases where losses lie where they fall. But if one puts those aside, I don't accept what Mr. Wilcox says about a ratepayer having to effectively put in a multitude of proposals. And it would be possible to put in a single proposal, provided that it was effectively put in at a time where whatever the time when the event which ended the circumstances giving rise to the alteration had effectively been superseded by a later series of events. And I think probably the last thing I need to do and have time to do is just refer my lords to Regulation 4, which is a provision that Mr. Wilcox took you to.
Yes.
Behind tab 5. Paragraph 3, no proposal may be made by reference to more than one ground, unless for each ground relied on, the material day and the effective date are the same. That is the provision that my lords were taken to, but that is dealing with, that is effectively a prohibitory provision where proposals are made on different grounds. But if proposals are made on the same ground, then it is possible for a ratepayer to propose different effective dates.
I'm sorry, I think I must be in the wrong tab. Could you give me the tab again?
Yes, my lord, it in fact appears in a number of places.
I think tab 3 is where we...
Yeah, we were taken
morning.
to tab 3 by... tab 3...
Page 15 in the paper bundle.
Just
Yes, thank you.
I think Mr. Wilcox made the point that the forms militate against that.
Well, my lord, the forms are not... in some statutory contexts, forms are mandated by the legislation itself, and that's not the case here, as far as I...
Yes, I know, but in practice, a ratepayer may not choose to do battle with the form that they are offered.
Yes.
And so they lead to filing more than one form, if that's the course of the saying. But you're saying there's no law.
Yes, that's exactly what I'm saying, my lord. And I'm saying, and I suppose that the last point that I really wish to make is that the need for a ratepayer to make a series of, or any protective steps in relation to a list which the ratepayer considers to be inaccurate is exactly what is anticipated by the statutory scheme. So it is no argument to say, as Mr. Wilcox does, that, oh well, this, that if Regulation 38.7 is exercised in a way which causes the persistence of an inaccuracy, then a ratepayer will have to take protective steps in relation to it. That is exactly what the legislation contemplates by providing the ratepayer with the ability to make proposals, and in reality cannot be used as an argument against the interpretation that I advance. My lords, I'm very grateful for the indulgence in terms of the extra time. Those are my submissions, unless I can assist further. And I should also say that I did undertake to deal with the limitation provisions in relation to the intervention that my Lord Justice Arnold asked me about earlier. I haven't had time to do that, for which I can only apologise. Perhaps
If I remember rightly, you do deal with that in your skeleton argument.
Yes, I do. I do. And I did answer directly at the time the second rider to the question that my Lord Justice asked me.
All right, not to worry. But that was the main point.
I'm very grateful. Thank you.
Good. Well, thank you very much, Mr. Mackenzie. So yes, Mr. Wilcox.
My Lord, I'm grateful. I have a handful of points, and I'll be as brief as I can. I certainly won't repeat anything that I've said in primary submissions. My Lord, I'll begin, if I may, where my learned friend just left off, about the ability, submission I was extremely surprised to hear, that if you're making multiple ground B challenges, you can have as many material days or effective dates as you like within a single proposal without offending Regulation 4.3a. My Lord, that will come as a surprise to anyone who acts for ratepayers in making proposals. It's simply not how the system works. And my Lord, that can be seen If you're in tab 3, please, from page 16, the provision we haven't been to yet, which is Regulation 6. Regulation 6, my lord, prescribes the information which has to be given in respect of a ground. You can see Reg 6(1)(e) at the bottom of page 16. Says the proposal shall include, small 3, in the case of a proposal made on the ground set out in Reg 4(1)(b), a statement of the nature of the change in question and of the date for which the proposer believes the change occurred. Lord, it is clearly envisaged in these regulations, and even more clearly envisaged in the regulations which replace them, that a ground equals one MCC. If you're going to raise multiple MCCs, you are raising multiple grounds. So my learned friend's submission simply doesn't stack with the way the system operates or the requirements of the content of proposals.
All right. Let's assume you're right about that.
Lord, yes.
I'm still unable to understand why it is, or what there is in the legislation that prevents a document being submitted, never mind what is on the website, but in the legislation, what is there that stops you putting in one document, a statement to say, I have 2 proposals. Proposal 1 is that the property in question ceased to be a hereditament because it ceased to be capable of beneficial occupation, and therefore I want a nominal rateable value as at the 1st of September 2014. Proposal 2 is that the physical state of the property has changed, and therefore the rateable value should be reduced as at the 23rd of January 2015.
My lord, they're evidently 2 proposals, as you say. My lord, it may be that it is legally possible to include them in one document, but the submission I made earlier, in which I stand by, my lord, is that a ratepayer would be very ill-advised to proceed in that way, because it is likely, in my submission, that the valuation officer would say that that was properly construed one proposal, which was an invalid proposal because it raised grounds with different material days.
Could you just remind us why this matters?
And well, this matters because of the need for a multiplicity of proposals, and in my submission, if the scheme only works if ratepayers need to make a multiplicity of proposals to protect their position.
But in your case, you didn't. You just needed to make one proposal to turn the rates off and another proposal to turn them back on at the level that you said was.
Well, that's because it so happened that the VO agreed with my client about when the scheme ended, but that's not a given at the time the proposal was to be made. It's never a given. There are many cases where there are disputes about when the scheme ends for these purposes. And as I submitted before, my lord, I'm in danger of repeating myself, but the well-advised ratepayer would make a proposal against each of those dates in the event of a dispute. And of course, you don't know if there's going to be a dispute on that until you've made the proposals. So it's.
But again, and it's probably only me. Why does it matter to our interpretation of Regulation sub 7?
My lord, because if my learned friend is right, then the effect of Reg sub 7 is that ratepayers are placed in the position of needing to make multiplicities of proposals. My submission is that faced with an interpretation which puts that onus on a ratepayer versus an interpretation which puts the onus on the VO, which one of those is likely to be correct? Bear in mind, this is not a context where self-assessment applies. The obligation on maintenance of the list is on the VO, it's not on the ratepayer. Well, that's the reason I advanced the submission.
Thank
A
you.
handful of other points. I'll begin with what I think are the 2 least controversial. In response to the question asked by my Lord Justice Henderson about where these provisions came from, whether this has been around forever.
Thank you. Yes.
My recollection, my Lord, I may be wrong, but I don't think I am. My recollection is that a provision of this kind has been in every iteration of the procedure regs since the 1988 Act entered force. I've searched for an explanation in any of the explanatory notes or anything like that for why it's there, and I've not been able to find one. So, my lord, it comes to us from antiquity, and none of us knows why it's there, I'm afraid.
That's why I rather thought that was the position, but thank you.
My lord, it helps me to clarify that. The other fairly straightforward factual correction, my lord, relates to a submission my learned friend made about the position at the time of the Upper Tribunal decision under appeal as to the correctness of 1.8 versus 1.83 million for this hereditament. I've taken instructions on that, my lord. My instructions are that the Upper Tribunal decision in this case was given on the 25th of February 2020. The Upper Tribunal case on the valuation was heard on the 12th of March 2020, and the decision was handed down on the 24th of March 2020. So, my lord, at the time of the decision of the Upper Tribunal in this case, the correctness of the 1.83 million was not yet established. That appeal was the valuation officer's appeal against a different view of the Valuation Tribunal, which is cited in the decision under appeal. So, my lords, just so there's no misunderstanding about the sequence of events, at the time of this appeal, competing inaccuracies remained the correct analysis.
Thank you.
My lord, my learned friend relied substantially at several points in his case on the proposition that it's not the operation of Regulation 38.7 which introduces the post-scheme inaccuracy. As it were, I think he argued that there was no causal link between the exercise of the discretion and the presence of the inaccuracy. My lord, that submission doesn't follow through when one considers how tribunals behave in this context. My lord, as my learned friend submitted, and as I agree, the ordinary role of the tribunal is to determine whether or not a proposal is well-founded. If it considers the proposal is well-founded on the material day, the tribunal changes the list from the material day, or from the effective date, I should say. My lord, that is the ordinary course of events. It's made very clear in Leader, in the passages I took you to, that that is the ordinary course of events. The question then becomes, if the ordinary course of events is followed, i.e. but for the operation of this discretion, what would the state of the list be after the end of the period? And the answer to that question is it will have a nominal RV. So it is precisely the exercise of this discretion which causes the inaccuracy to be in the list. The discretion involves a departure from the ordinary course of events, which causes an inaccuracy which would otherwise be expunged to remain in existence. So, my lord, I simply don't accept that there's no causal link. There is precisely a causal link, and that's precisely why the implications of introducing inaccuracies in this way forms a part of my case. My lord, there was a question, I think, from my Lord Justice Arnold, but forgive me if I'm wrong, about how this would operate in a limitation-free world, if I can put it that way. My lord, in a limitation-free world, it is always open to the VO to put right any problems in the list after the material day of the proposal. So, my lord, there is no need for the operation of Regulation 38.7 in that sort of circumstance. Where Regulation 38.7 might have a role in that sort of circumstance is in dealing with what I call ABA cases, where in giving effect to a temporary alteration, the accuracy of the list is furthered. To operate Regulation 38.7 in an ABC world, for the reason I've just reiterated, perpetuates inaccuracy. And in a limitation-free world, there is no need for it to do so, because it is open to the VO to do its job, to discharge its duty, to correct the inaccuracy.
What do you say to the argument that we're not in an ABC or an ABA world at all, we're in an AB world?
My lord, what I say to that is that the tribunal has to consider whether you're an ABC or an ABA world to decide whether the circumstance has ceased to exist, when the circumstance is properly understood. I certainly don't intend to detain the court by repeating why I say the circumstance in this case is the stripping out works. But, my lord, if you are to consider whether circumstances have ceased to exist, it is in my submission not only relevant but necessary to consider what happens after the alleged cessation. I can deal with this by reference to an example, and indeed this is an important point that my learned friend made about scaffolding. He said that the erection of scaffolding doesn't cease to exist when the scaffolding is taken down. I think if I summarise him very briefly. My lords, the difficulty with that submission, of course, is that if you remove scaffolding that you've put up, the act of removal undoes the whole of the act of erection and nothing more. The one cancels out the other purely and cleanly. There's nothing more, nothing less. That, my lords, is a cessation of the circumstance. That's what cease to exist means in this context. If what you have is the removal of the scaffolding and the addition of something different, then that's not a cessation. It's a replacement. One circumstance replaces another. So, my lord, to test whether or not there has been a cessation, it's necessary to go beyond AB. You have to ask, is it ABA or ABC? And as soon as you recognise that feature of cessation, that quality of the language, then the restriction of this provision to ABA cases must follow in my submission. While I'm on ABA versus ABC, my learned friend seemed to place some reliance on the fact that it was the same hereditament before and after the scheme. My lord, whether or not that's so, it is undoubtedly a different set of physical characteristics before and after the scheme. Whether it falls to be assessed as the same hereditament or a different hereditament, if it's the same hereditament, it's acquired new characteristics. It's got a staircase now. It's got a reception now. My lord, that's what matters. Whether it's a new hereditament or the same hereditament is nothing to do with my case. It's about have the reality factors altered before and after. So, my lord, the hereditament same or different point in that sense, in my submission, is something of a red herring. In my case, certainly doesn't turn on establishing that it was a new hereditament afterwards. My lord, yes, two more points, and I'm done. The first point relates to my earlier friend's submission about the difference in role between the VO and the VTE in the tribunal. My learned friend said it's the valuation officer with the obligation to keep the list accurate. It's not the VTE with the obligation to keep the list accurate. And my learned friend's absolutely right about that. The role of the VTE is not one of general list maintenance. It's one of, is the proposal before it sound or unsound? And the proposal before it will be concerned, by definition, with a single day, the state of affairs on the material day. Is what is suggested needs to change on the material day right, or is it wrong? That's the question for the tribunal. It's the only question for the tribunal. And my lord, that's what demonstrates the exceptionality of Reg 38.7 in this context. It is an exceptional departure from the usual position. And where you have an exceptional departure from a usual position, one would expect it, generally, but not least in a fiscal context, to be narrow, not broad.
I may have misunderstood your submission, in which case I do apologise, but you seem to be saying that the VTE's jurisdiction requires it to decide day by day by day. Can that really be the case?
My lord, no, that's not the case. The VTE's jurisdiction is to decide the proposal before it, and that proposal will concern a day. So that the VTE will say, if the proposal's material day is the 1st of June, will say, on the 1st of June, was the list accurate or not, in the way that it's challenged by the proposal. If the answer is yes, it was inaccurate, the tribunal changed the list on that day. And that change will continue.
Well, exactly.
For every day thereafter.
So although it judges the position as at a material day, its decision has consequences for all the following days.
It does, my lord, and if those consequences are inaccurate, it's the VO's job to put them right. That's the leader point. It's not for the
Which
tribunal.
seems to be a submission that the VETE is constrained to make decisions which it knows are inaccurate.
My lord, it's not, because it's concerned simply with the state of affairs on the material day. The VTE is concerned with a narrow question. It's precisely...
If it always knows that its decision has consequences with regard to the following days, how can it possibly shut its eyes to that? It can't simply adopt a blinkered approach and say, OK, this proposal only concerns the 1st of September. Therefore, we only have to worry our poor little heads about the 1st of September. We don't have to worry about the 2nd, the 3rd, the 4th, the 5th of September, even though they know that it will have consequences for those succeeding days.
My lord, that is exactly what the VTE has to do. Yes, but for it to do otherwise would be to trespass on the valuation officer's role. It is for the tribunal to determine the proposal before it. That's the extent of its jurisdiction. For it to concern itself with events after the material day is to go beyond the four corners of the proposal which defines its jurisdiction. And it doesn't leave a lacuna, my lord, because the VO is there to fix those inaccuracies. The relationship is a symbiotic one, as Leader makes clear. It's not for the VTE to fix every ill with the rating list. It's not its job. It's not empowered to do so. And that is that way for a reason, my lord, because when it's the VO that fixes those subsequent problems, rights of proposal arise for the ratepayer if it thinks the VO got it wrong. Protections of limitation, protection of non-retrospective increases arise. If the tribunal does it, none of those protections arise. It cuts out an essential first stage of deciding what should be in the list. Lord,
But this seems to be a very cockeyed view of how the tribunal should operate, because what you're telling us is that the tribunal's competence is limited to deciding the position as at a single day. It knows that its decision will have knock-on consequences for the successive days in the list, but it's required, you say, to put that out of its mind and to leave it to the valuation officer to deal with the knock-on consequences.
Lord, yes, that's right. That's how the regime is structured. And it's that way for a reason. It's so that rights of proposal arise in the appropriate way, and the decisions about what happens later can be determined by the person who has the duty and the information to do so. So worth bearing in mind, my lord, that the evidence which will be included in a proposal will be targeted at material day. It has to be. So the tribunal may think it's going to give rise to a problem later on, but it won't necessarily have the evidential foundation to know that.
The person who will best know what's going on is the ratepayer, in terms of the physical facts. You've said, I understand, that there's an obligation on the officer to keep the list accurate.
There is, my lord, yes.
But that is subject to the right of the ratepayer to make a proposal.
It is, my lord, yes.
So in this case, your client only had to make a proposal at the end of the time, in the same way as it made a proposal at the beginning of the time.
Well, my lord, it would have been open to my client to do so. But
Yes, well, if it chooses not to do so, why is it entitled to come here and complain about overtaxation?
my lord, it's entitled to do so because it's not my client's job to keep the list accurate. It's the valuation officer.
No, but it's your client's job, and I don't know whether it's a company or a partnership or whatever it is, to look after its own money, and to take the steps that are open to it in law to do so. Were you going to tell us how much was involved? I think I asked you before.
You did, my lord, and my understanding is your calculation was correct. The difference between the 1.8 that should have been in and the 1.83 that was in was about £2,500. Yeah.
Right.
But again, my lord, I come back to the point. The ratepayer can act to protect itself. It can act to raise the...
Yes, but if it chooses not to do so, does its complaint about the unfairness of the whole system really count for very much?
Well, my lord, in my submission it does, because the ratepayer is entitled to expect the list to be maintained accurately, because there's an officer appointed.
Yes, but if I get a tax assessment and I don't like it and I choose not to do it, nobody's going to be very impressed if I say it's extremely unfair, I'm being overtaxed.
Well, my lord, I think I'm in danger of venturing out of my area of expertise here, but I think if one refuses to respond to an assessment one is obliged to deal with, then the position's rather different. But there's no obligation on a ratepayer to put a proposal in at all. Ratepayers have a right, but they're not obliged to maintain the list. That's not how the system works.
So you don't complain about something, and then, because of a chain of circumstances, seek to defend. I mean, you wouldn't be here for 2,500. You seek to defend a huge windfall.
Well, what we seek to defend in this case, my lord, is the simple consequence of limitation working in accordance with how this provision operates as a matter of law. I'm in dire danger of repeating myself, my lord, but in circumstances where one person has a right and someone else has an obligation, ratepayers are entitled to proceed on the basis that the list will be properly maintained.
Or, pushing the limitation point, you say you're entitled to take the limitation point, as is any person who has a limitation.
Well, my lord, quite so.
Working in their favour.
If limitation expires, then limitation's expired. What you don't expect to do is find limitation expired and then an unsuitable procedural device being found within the tribunal's regs to try to get around it to your detriment, which is what's happening.
I'm sorry, I'm repeating myself now, but the scheme of the legislation is not that the valuation officer has to keep the list accurate, and that's an end of it. The scheme of the legislation is a complex set of checks and balances, as I understand it, which allows both sides to exercise their rights in order to try and get as near to the accurate figure as possible. If one side chooses not to do that, they don't do it. They're not obliged to do it. They can't both not do it and then complain afterwards.
Well, my lord, the answer to that, and I again repeating myself, is that there is an asymmetry of power and duty here. The ratepayer has a right.
I understand they're not identical. They're not identical in their positions, the officer and the ratepayer. Of course they're not. But the legislation allows people in your position to protect themselves if they wish to do so.
Well, it does, and people in my client's position shouldn't have to. They should be entitled to expect a statutory officer with a statutory duty to discharge that duty properly. And if that doesn't happen, my lord, the ratepayer shouldn't be penalised for it.
I understand.
I think one final point, which relates to primary facts and the mixed fact and law point. I'd simply point out that my learned friend's submissions about how primary facts and law are all mushed together and you don't need to be precise about what the circumstance is directly contrary to what Merlin tells you. Of course, you need to look at the consequences in deciding the valuation impact. Just as in Merlin, you needed to look at the extent of the change in footfall to decide the extent of the list alteration following the change in attitudes. But it doesn't make the change in footfall the circumstance. It's the attitude that's the circumstance. And that's important for reasons we've already submitted. So if my learned friend is right about that, then Merlin cannot stand. And that would be, given its the authoritativeness of its author, that would be a surprising position. Unless I can assist any further, my lords, those are my submissions in reply.
Thank you very much indeed, Mr. Wilcox. Nothing further from us.
Very grateful, my
I
lords.
think that concludes the argument on the Avison Young appeal. So I'm afraid rather late in the day,
My lord,
Mr.
yes,
Cromwell.
I'm in your hands, my lord. I don't wish to weary you, and a lot of my written submissions will probably make, hopefully, more sense now that my learned friends have so carefully taken you through a lot of material. I was going to address you on three separate points: the factual background, the power existence thereof, and the discretion. I noticed the time. I was hoping that I'd be able to just address the facts now in the next quarter of an hour, and then address those other two matters tomorrow.
Well, subject. I mean, we're starting. I think a subject. The timetable envisaged you would have been starting at 3:45 rather than as we now are 10 past 4. Subject to my what my lords say, I mean, I think I would be content for us to sit for another 15 minutes or so. Is that okay? That's all right for both of us. I don't think we can go much. We can't really go beyond 4:30.
Of course.
But I hope that will then leave enough time tomorrow for you and Mr. Kolinsky. I think I see a nod from Mr. Kolinsky. In that case, I will keep quiet and let you give you the floor for the next quarter hour or so.
My lord, yes. And on the factual background, one of the points that arises with great clarity in the very last point my learned friend was making is that on his submission, there is no 38.7 power at all. There is no need for it because the effective submission being made by my learned friend is that the tribunal determines the proposal to a point in time, and any consequential matter falls to the VO to amend the list appropriately.
Yes.
Now, in many cases, that's absolutely not problematic because the VO has that power. So the materiality of the 38.7 discretionary power doesn't arise because the VO can make the change anyway. It is precisely where the VO is unable to make the necessary change, where this 38.7 power starts to have materiality. And so to your lordship's question, well, you know, how long has this provision existed? My own friend was right, it goes back to the NDR alteration of the lists and appeals regulations 1990, where it was in a slightly different form. It's regulation 42.5 for your but there doesn't seem to be any law on its meaning or dispute about it until pretty much these appeals before you. And I rather imagine that maybe because in the majority of cases it might not much matter whether the tribunal exercises 38.7 power because the VO can alter the list anyway at the end, as at the end date. And so where Mr. Wilcox's, and with respect Mr. Kolinsky's QC's submissions, they proceed on a prospective view of the problem. You have a problem, the proposal in respect of the issue, so incapability of beneficial occupation, that's resolved, and then when, insofar as it becomes a hereditament or capable of beneficial occupation thereafter, then the VO can do it. Whereas the operation of 38.7 is retrospective. It's looking at circumstances that have already finished in the past. And that's of critical importance. And so going to the factual background to make that point in this appeal of Great Bear, and I turn by reference to my skeleton argument at paragraph 4, which you find at page 12 of the Great Bear bundle.
Yes, thank you.
The appeal property is a purpose-built warehouse. It was in the 2010 rating list at £825,000. Ratepayer undertook work to the property between the 23rd of June and the 3rd of October 2014, which included the demolition of a small office block which adjoined the main warehouse and alteration to the dock levelers. Among other things, but those are the things that the tribunal pointed to in particular. For your assistance, just to get some sense of it, if you turn in the bundle to page 107, please, which is behind tab 13.
Yes.
Page 107, you'll see on the bottom right-hand corner existing building plan.
Oh yes. Oh, yes.
And you'll
Hard
see
to
at
read.
the bottom of the plan, it says ground floor office, this small triangle. So this is the main warehouse that you see, the main warehouse there. And then right at the bottom, you see ground floor office,
Oh,
which
yes.
is sort of external to the main warehouse.
Yeah.
And next door, you see first floor office, which sits upon that ground floor office.
Yes.
And then on the right-hand side of this document, you'll see these sort of small rectangles with X's.
Yeah.
Those are the loading bays, or the dock levelers, which are the material which assist the transition of goods from the warehouse to the vehicles. And there are 11 there. And then if you go over the page to 108, you'll see what's effectively happened is that office at the bottom has been demolished and it was replaced by further car parking.
I see.
And
Yes.
the dock levelers were replaced by, I think, 10 different dock levelers replaced the initial 11. The plot of the land as a whole was no different. For reasons that I'll go into tomorrow, it's important not to sort of overstate the extent of the change that is undertaken here. There are photographs that you'll also see which make the same points for your notes, page 110 as against page 114. It is agreed that during the process of those works, the property was incapable of beneficial occupation. On the 4th of October, the ratepayer resumed beneficial occupation of the property, and that's agreed. And you will obviously recognise that at that point, the property remained on the list at £825,000. And at that point, ratepayer, if it considered that that valuation was too high, could make a proposal to say that the valuation should be less now. On the 2nd of February 2015, the ratepayer submitted the proposal that the existing entry be deleted with effect from the 16th of June 2014 as a result of building works. And you find that at tab 17, page 139. And you see under Part C, grounds for the proposed alteration. I believe rating this is inaccurate because the property has been demolished or no longer exists. And then the detailed reasons, as a result of building works, the assessment should be deleted with effect from the 16th of June 2014. So the proposal that the ratepayer made was that there was building works and as a result the hereditament should be deleted.
It's a bit odd on the face of it because at first value, not knowing what lay behind it, one might think this was saying that the entire thing had been demolished.
Yes, exactly. I think, I'll be corrected if I'm wrong, I think E may be a pro forma checkbox that is selected down where grounds...
So there wasn't an option of partial demolition.
Yes, exactly. And so when they then actually go in, they say, well, they're building works. That's why we say it's deleted. But what's important is that at that point, and indeed before, the ratepayer could have also made a proposal to say, as of the 4th of October 2014, the rateable value, it shouldn't be 825,000. It should be 745,000. I mean, Mr. Wilcox made the point that the results of the proposal are never a given. It could the ratepayer wasn't entitled to assume that this deletion proposal, because of the works, would have the result A, that it would be accepted, or that if it were accepted, it would continue not only for the period of the works, but all the way through beyond the point of beneficial reoccupation to the end of the list on the 1st of April 2017.
Are the details on the following page details that accompanied the application?
I understand not, but I will. No, I have to deal with that a little bit tomorrow, Your Honour. But my Lord, excuse me. As a matter of fact, I think what happened is that the representative valuation officer attended the site in, I think it was April 15, and saw that there was a warehouse in existence there. At that point, the Court of Appeal in Monk was saying, well, you know, due to building works, it doesn't mean there's no hereditament, and that was then appealed to the Supreme Court. So, but
I mean, having looked at the proposal and the photographs and so forth, one wouldn't know whether what had taken place would lead to a reduction or an increase or no change.
My Lord, exactly.
It's not immediately apparent what's going on here.
Exactly, and one of the responses to my learned friend's references to sort of asymmetry of obligations, there's also, conversely, an asymmetry of knowledge. The ratepayer knows what is happening at the hereditament. And if the ratepayer feels that it's now overvalued because there's some change, the ratepayer has the opportunity to...
Well, there's also an asymmetry of interest.
Yes.
In some degree, being the one person against the state.
Yes, I mean, I think certainly it's no answer to say, well, we were entitled to rely upon a deletion proposal in order to protect our position even after the point where we had resumed beneficial occupation of the property. And so it was that, and then incorporating the points in my learned friend's argument skeleton at 38, which goes to the painful question of Regulation 14 and the effective dates and so on. But I respectfully agree with what's set out at this paragraph 38. So the position was, on 2nd of February, the ratepayer made the deletion proposal. As I said, you already have the point that they could have made a further proposal for a reduction of the rateable value from the 4th of October. The position slightly changed on the 1st of April 2015 by virtue of Regulation 14.2c as amended, because from that point, the ratepayer wasn't able to make a proposal which would have effect all the way back to the 4th of October 14. It would only have the effect of going back to the 1st of April 2015. And so that's my learned friend's point 38A. But the point remains that all the way through to the 31st of March 2017, for 2 years, the ratepayer still had the opportunity to make a proposal that the rateable value, which remained in the list at 825, was since the 1st of April 2015 too high, and no such proposal was made. Monk was heard and decided on the 1st of March 2017, and my learned friend is right to say it wasn't until the 31st of March 2018 that the valuation officer lost the ability to alter the list otherwise than as a result of a proposal, which is the effect of Regulation 14.2b and Regulation 14.8. I'm not sure we've seen Regulation 14.8, but that basically provides that once there's a new list, and the new list was 1st of April 2017, you only have VO only has a further year to make any change. Monk was decided. This came to the we were finally listed for the VTE in 2019, and there was then, I think, the substantive discussions between the parties as to the nature, the evidence in the proposal and so on. And the VO agreed that it had been incapable of beneficial occupation for the period, and then proposed the temporary limitation. And that was disputed, and so we are where we are through the VTE and the Upper Tribunal decisions. The point is, obviously, that by the time of the tribunal decision, first you had, throughout this period, in the list for every day, the hereditament at 825,000. And the second point was that if the hereditament was to be deleted at the commencement of the works, but not thereafter, that would mean that the VO couldn't put it in at the end of the works, which would have the result that for 2.5 years of beneficial occupation of a property that everyone would agree was otherwise a hereditament, there would not be a hereditament in the list. And to my Lord Justice Jackson's point about the materiality in fiscal terms of what that difference is, 2.5 years of a valuation at 825,000 is approximately, and I think it's not disagreed, over £900,000. The precise amount is difficult to summarise because there are slightly different rates for any particular day, but I think my learned friends and I agree that it is at least £900,000.
So the best part of £1 million is basically escaped.
Yes.
In a situation where liability would otherwise be irresistible.
Exactly.
If the exercise of discretion by the tribunal stands.
Exactly. Conversely, obviously, what the tribunal were troubled by, and I'll deal with it tomorrow, but is if it was left in the list as it stood at 825,000, that might be 80,000 more of valuation, which would be approximately 90,000 more in rates over the same period. And so,
in your case, it's 90 versus 900.
Exactly. So if there's no hereditament, then there's 900,000 that would have been paid that hasn't been. But if the hereditament is left in at 825,000 at a level that no one can do anything about now, that would result in 90,000 more than had there been on our case, had there been a valuation proposal and accepted and changed to the 745,000.
Yeah.
So it is this really is a case where this power under Regulation 38.7 has a real impact and effect, and that's precisely why we say this is merits your consideration now. My lords, I'll obviously develop the other 2 points tomorrow, unless I can assist further.
Good. And Mr. Kolinsky, this will give you adequate time. I hope tomorrow you're satisfied about that.
My lord, yes, I think we'll have time to be fairly close to my time estimates, and I'll try and make it
Thank you. Thank you very much indeed. Well, in that case, I think we will start at the usual time, 10:30 tomorrow. Thank you all very much.
Dr.